Corrections, Human Services, the county board, and most importantly, the participants. You're all aware the drug court team has had an evaluation completed, not to show how good we were doing, but to point out those areas in which we could improve, and we all can. I've heard from people that our drug court is failing, but nothing could be further from the truth. We are working on improving those areas pointed out in the evaluation, and there is now law enforcement on the team. We've expanded the training for team members, and we have additional training planned. We have updated our policy and procedures to reflect some of those changes, and we are presently developing an aftercare program, and I have to say Lizzie from probation and parole is doing the most work on that. The goal of that is reducing the level of recidivism that we do have. There's also an updated job description for the coordinator position that accurately reflects the duties of the job, which I hope to present approval to various committees, assuming that we can put this whole matter behind us today. I will admit, it has been a struggle without a coordinator to conduct the business at drug court, because it's fallen on those of us who have other jobs. And it has made it more difficult, but the effort has still gotten done. We still have a viable, working drug court. I do want to thank the board for the time, effort, and the thoughts you've put into this worthwhile program. Over the past several months, I want to thank you for having this special session focused on drug court, and I hope that as of tonight, everything gets resolved and you allow us to move forward. Thank you very much.
Yes, ma'am.
Good evening. I am Michelle Brill. I am a mental health treatment provider at Anchor Bay Counseling. I've been involved in the Rusk County Drug Court since its inception 9 years ago. I have had the privilege of being part of this program since Judge Anderson brought this endeavor to our community. I've had the opportunity to go to Washington, D.C. twice to be actually trained so that we would be able to not only follow the standards of our local community, but also national standards. I just want to assure you there are a lot of well-informed people that want to see this program continue. Despite other issues that may be going on, like Rich, that I don't really want to know about, I'm thinking about the clients that I've worked with over the last 9 years, as well as the graduates that are now functioning members of our society. Some of them came 2 months ago to speak to you. They were terrified. I'm so proud of them. And lastly, I just want to say, it also, not as a drug court team member, not as a therapist from Anchor Bay, I want to say as a community member, I think tonight's decision, just from what I have heard, once removed, but from our community, is tonight the decision I think is really going to send a message about what the county thinks about rehabilitation and recovery, about trauma, and about substance abuse, and the effects on people and their families. And I just ask that that be considered. Thank you.
Anyone else?
Hello, y'all. My name is Timothy Tinker. I'm here tonight to voice my opinion about the drug court program. Let me start by saying that I support this great program. It's a success. And the reason why I call it a success is because if we save one person from the jaws of addiction, it is a success. And it seems to me like this council does not want the program to be a success. And personally, I know one person, actually I know several, but I'm going to speak on one individual who was a success. And this person I watched go from being a great individual to being a horrible piece of garbage, the epitome of evil, and then was snatched from the jaws of addiction because of this program. And y'all want to get rid of it. Y'all want to control something you know nothing about. And I watched drug court take this person and become a productive, self-sustaining member of this very community. And I'm proud to call them my friend. So I don't understand what the question is or why we're even here. If it's about money, I believe the program is funded almost 100% by the Department of Justice. and that minuscule amount we as a community can come up with to continue this program. There's people on this committee, or on this council, who are stubborn and bullheaded, and who have a problem with Judge Barna. I've seen it 2 months ago when I watched you people address her as Annette, not Your Honor, not Judge Barna, nothing like that. And I know the previous judge, none of you guys would have ever addressed Stephen Anderson that way. Would any of you have called him, hey Steve, I believe this is the way it should be? No, y'all would have said Judge Anderson or Your Honor. And that's absolutely disgusting that you're willing to put a program to the side and get rid of it because of your disdain and contempt for Judge Barna. She's been with the program since day one, knows the workings inside and out of this program. But yet you all sit up here and want control and want her out. Why? Is it because you want the money from the revolving door upstairs? Rearresting the offenders and then setting them free to continue their addiction and continue crimes? Is that what this committee or this council wants? I sure to God hope not. Because as a citizen of Rusk County, that's not what I want. I want to see these people on the road to recovery and become productive members of society again, like we all know they can be. And with that, I thank you and have a good night, ladies and gentlemen.
Thank you. Anyone else?
Good evening. I wasn't at your last meeting. I gave you a letter of my feelings with regard to drug court. Now, I'm a member of the drug court team from the private sector. I was very honored and grateful to Judge Anderson, who asked me to serve. In fact, it's one of those times when your office gets a call from the judge's office that he wants to see you, and then you're all thinking, oh, what did I do now? But that's what he wanted to see me about, and I gladly accepted to be part of this team. And I've learned a lot in the last 2 years. But one thing that struck me, and I'll be very honest with you, when this program first came out, I was like, okay, I'm a defense attorney, I'm gonna have to learn about it. Is this gonna work? Is it another crock of our statewide money? You know, is it really gonna be helpful? But what I did, I started coming to the open meetings that they had. And I learned about the program from the ground up. And that's important. And I think that's why Judge probably asked me to be on that program. But you have to start at the beginning to learn about it. And I was watching and following some of the participants, and I didn't make it every Wednesday due to my schedule. I probably averaged about once a month. And maybe a little bit more than that, but I really learned a lot. And I saw how some of these individual lives were changed. And I'm not sure here at this time today why we got to where we are, but we're here. And I don't have any authority from the drug court or from any member, but one of the things I think we have to establish is that if you keep this program, this viable program, we need a community member. And I certainly would have to propose that to the drug court team. But I think as a community member, why not have a member of this body serve on our team and be part of it from the ground up like I did? Now, we get no compensation. I get, and the other people that work on this are obviously county employees or state employees. I come from the private sector. There's a lot of times that after our meetings at 7 o'clock in the morning to 8, I can't stay because I have other commitments when we actually talk to the participants. But we have a great rapport on this team where we learn what happens through other forms of communication so that we know what their responses are, and I'm up to date on all the participants. And I try to stay as much as I can, but there's obviously times that we just can't. And we also have a public defender on the program, or on our team, excuse me. and we share a vote. But we usually cover it that we have at least one defense attorney there. We have the Department of Corrections. We also have her supervisor there on those meetings, which is very helpful. We also have the district attorney's office, either one or both of them there. We also have, as you said, Ms. Rail. We also have a member of the Department of Health and Human Services, in fact, 2 members. And I don't want to call them, we have Rich. And we have, most importantly, I think, from our community, from that standpoint, we have a member or detective from our department, or sheriff's department, Mr. Riley Cumming. And things have really changed. And I guess what I want to say to you is consider potentially what I've said, my proposal. Think about it. The point is not to accept that as a proposal, but to put the lines of communication open so we can discuss these things, because we can work together. Thank you.
Thank you. Anyone else? Yes, sir.
Good evening. Appreciate the opportunity to speak. I know a few of you in here. My name is Bill Stewart. I am a resident of Rusk County. I pay taxes here, so I have a right to be heard, I guess. I'm a retired circuit court judge from Dunn County. I sat on the bench there for 16 years. Part of my duties in Dunn County were to start the treatment court. They included drugs, alcohol, and other disabilities. And I ran that for 9 years. I have, and I still serve as a reserve judge as long as the chief judge, who's sitting behind me someplace, allows me to do so. But that means I get to sit in different counties around our district, the 10th Judicial District. And over the years, as a reserve judge, when I called in, often I will be asked to supervise the treatment court in that county so that they don't miss a week because the judge is gone. So I've had a lot of experience, a lot of training, and one thing that I can tell you is that treatment courts work. They have to follow certain principles, procedures, policies. They have to be staffed appropriately, but they do work. And when I say they work, what I mean is a couple of things happen. One is you have people that are much less likely to re-enter the criminal justice system and get on that roller and just keep coming and coming and coming. As a judge, I saw plenty of that. But I also saw less of it when we had the availability of treatment courts, because as in Rusk County, we had a lot of meth issues along with other drugs, but that was the principal one that I dealt with in my career there. They work. They help you reduce the recidivism of these people coming back, coming back, coming back. The second thing they do, and this is the one that's hard for most people to swallow, it makes your community safer. It makes it safer. And that's one of the goals of a treatment court, is to, one, keep people from recidivating and coming back and back and back, and then they lose their kids, their spouse gets involved, and then you, as a county board, can take financial responsibility for everybody because they're untreated addicts who can't raise their children. It makes your community safer. Now, I have been on the Criminal Justice Collaborating Council in Rusk County for about 9 years, I think. Judge Anderson asked if I would participate. I said I would be happy to do that, having operated the Criminal Justice Collaborating Council for a number of years. And I have been actively involved. I don't have a clue what the issues are with regard to the drug court as we sit here. And that's okay. I understand the process, I know how it works. But I can tell you that if Rusk County loses the opportunity to maintain the treatment court, you will be the worse off for it. There are costs involved with that. Okay? When you have more and more people coming through the system, it costs you more money. You need to build new jails, more jails, bigger jails. And one of the things that we know from looking at the history of treatment courts in this country and across the world, as a matter of fact, is that they cause the need for jails and prisons to lessen, because people get treatment. And I can tell you as a sitting judge, one thing that just bothered the heck out of me, is every time I sent someone to prison, I could almost be absolutely assured that they would be released untreated from their chemical dependency. Now you're gonna say, well, how can that happen? Trust me, it happens every single day. And where those people go, they come back to your community. Untreated addicts. So if you want a system that works better, you need to continue these kinds of efforts. They're really important. They are. And they'll make your community safer. And I can tell you, just this in closing, and I apologize for taking up so much time, but there are issues with the drug court, as with all drug courts. One of the most frustrating things in trying to operate a drug court is things change, which means you have to change along with them. So are there changes necessary? Sure there are. But those can be done. And it needs a coordinator now. Thank you.
Anyone else?
My name is Joe Bay. I'm a resident of Rusk County. I have just come from a preliminary part of our scout meeting for the week. And I want to tell you the frustrating part of working with one of our men who's now in his early 50s, who has been a scout, and yet he has run into the problem with drugs, and he has been part of the drug court situation. Frustrating for me, frustrating for our leaders. However, we stand by him and want him to have the best possible situation to face those challenges, face those difficulties, and overcome them. We aren't talking about troublemakers that are 2 years old and go all the way up. We're talking about a variety of people in our communities. And the questions that I have are these. What is the primary purpose of ending the drug court? Do you say it doesn't work? Well, we have people here who say it does. We see these young people, these middle-aged people, at home with their families, or able to see their families, to be with their spouses. We need to know, is this what is best for the people of Rusk County? Are we investing in our people? Are we investing in in the children of people who have been taken in by this drug business? That is a serious question. And will we continue to invest in them, to allow them and their children and their spouses and their relatives to be part of a positive program? There are rumors that this situation is a situation of personal animosity toward the judge of the drug court. You hear these things. These are the things that should be brought out. These are the things that should be discussed. These are the things that we need to know about. When I would go to drug court on Wednesday morning, I would hear about the training that they were receiving in the MRT program. I would find out how many days that they were sober, sometimes going up into the 300s and the 400s. I would see that some of them were working, having jobs. I would see that some of them are, right when drug court was done, they were headed off to various types of counseling. and that's very necessary. All of us face challenges in our lives. I face a challenge of eating too much, and I'm really good at it. Some of us smoke, some of us drink, some of us do other things. They aren't necessarily always that serious, but we need to help those who need that help. We need to invest in these people. We need to invest in their children. We need to invest in their families. Now, it would be easy just to say, oh, to heck with it, get rid of it. Send those people to jail. But you just heard the judge say what the challenge is, what the problem is, if we don't invest in them. Let us talk about this. Let us bring together the people from the drug court who are involved with this. Let us bring in a couple of sets of parents. Let us bring in the county board members who are concerned about this, and let's talk about it. I talked to the Bishop of the Diocese of Superior, Bishop Powers, and he said that compromise and cooperation are not, I repeat, not mortal sins. Therefore, let us work on this. Let us talk about this. Let us work something like this through, so that we have stood by the people of Rusk County to help them when they needed help. Thank you.
Anyone else like to speak? Anyone else? If not, I'd like to thank all of you for your comments. They're well taken. And I can assure you that there's been a lot going on into this matter. And so with that, it's kind of going off into some deep water here. So I'm going to contact or call on our attorney and maybe you can kind of get us started here. And okay, yeah. Business agenda, discussion, possible action. Discussion with 10th Judicial District staff regarding Rusk County Drug Court program.
So this past spring, there was a confidential personnel investigation that was done with respect to the work environment within the drug court. And because a lot of this was discussed in closed session, I'm not at liberty to be able to share, with a lot of information about that. But there were two individuals involved in actually conducting the investigation. One was myself as an attorney with the Von Briesen and Roper Law Firm as outside legal counsel. And the other individual that was involved in the investigation was Caitlin Frederick, the Deputy Director for Management Services for the Wisconsin Judicial District. So 2 investigatory reports were issued, confidential personnel matters. And at a meeting in August, August 23rd, a letter was sent to the staff of the 10th Judicial District asking for guidance on how the district court was going to collaborate with the county on ensuring that the work environment for the drug court team is professional and respectful. In that letter, dated August 23rd, there were 3 specific questions that were asked that they were looking for some responses about that collaboration. And the 10th Judicial District responded on September 18th of just a few weeks ago and indicated that they would make themselves available today at a meeting to answer any questions and address the board with respect to this matter. I take it that Chief Judge Maureen Boyle is here?
Yes.
Okay, and District Court Administrator Ross Munns? Okay, perfect. So I guess at this point, I think the intention was to turn it over to you to, you had asked for the meeting, you wanted to address the board and answer questions. And then once it gets to a matter of talking specifically about personnel matters, then we will need to go into closed session to address that. But with respect to the drug court in general, which seems to be what was addressed in your September 18th letter, I guess we defer the floor to you to address that letter.
Well, thank you. First first of all, for allowing us to be here and for allowing us to participate in this hearing. And I have to tell you, after hearing all of the speeches here today and the public comment about the drug court, I also really question why this is even something that we're addressing here today. And I think that that was the most surprising part about the investigation and the reports that came out of it, because there seemed to be a disconnect from my perspective as a person looking at this from the outside. That we went from investigating a personnel issue to then it becoming a determination that perhaps the drug court should be suspended or dissolved. It's not entirely clear, actually, what the request is here or why. And I think we heard that from a number of the people who provided the public comment, was that there seems to be some sort of disconnect, and we don't really understand how we got to where we are here today. And that was clearly my position, and this is Ross Munns, who's the district court administrator. And so I think that's what we really wanted to address. And when we got the letter from the county board chair relating to these 3 questions, I believe we answered them. From our perspective, first and foremost, it is incredibly important that Rusk County continue its drug court program. Drug courts have been in existence since 2007, when the first treatment alternatives and diversion grants were instituted, and that's what TAD stands for those of you who might not know that. It began in the calendar year 2007. There was legislature had set aside about $700,000 to have various counties and tribes. These monies only go to counties and tribes. And there were 7 sites originally, and by 2012, the funding had increased to approximately $1 million. And if any of you have been watching the budget process, I suspect most of you have been, because of the direct effect it has on counties and county boards. You'll know that in the last state budget cycle, that the legislature has increased its support of these TAD grants, of these treatment alternatives and diversion, to the tune of an additional $1 million. So the amount of money that the legislature, that the governor, and of course local governments are in support of really demonstrates the value of these programs. And you know, the TAD program was evaluated in 2020, and of course at that time it wasn't necessarily statewide, but as of today, there are treatment courts in just about every single county across the state. The treatment courts vary. They include adult drug courts like the one here in Rusk County. There are family dependency treatment courts. There's hybrid courts for operating while intoxicated, and drug courts, juvenile drug treatment courts, mental health courts, opioid specific courts, veterans treatment courts, and healing to wellness courts. And those are typically the tribal courts, where they take a little bit different approach, utilizing their tribal traditions. And so these TAD grants have been really the basis of all of the alternative programming, because let's face it, folks, what we're doing isn't working. Judge Stewart, I think, said it very well, that just simply locking up people who have treatment needs doesn't result in any positive return. In fact, it is just the revolving door at the end of the cycle. We've all seen it. I have the good fortune of serving as the adult treatment court judge in Barry County, along with my duties as chief judge of the 10th Judicial District. I'm not really a staff person. I'm appointed by the Supreme Court to act as a chief administrator for the entire 10th District, which spans 14 counties and 31 judges, and all of which have treatment courts, except for Sawyer County, which is just now getting theirs underway because they've been waiting for their second judge. You may or may not know that they recently added a second branch. In fact, one of the requirements, and I find this really interesting, one of the requirements of that second branch was that there be a treatment court. in 2020, the legislature approved 12 new branches across the state for judicial branches. And the only way that a county would be approved for a judicial branch, second judicial branch, or however many it was, in Eau Claire they had a 6th branch. But they were approved for that because they had a treatment court. And that was one of the concerns of the legislature, is what are individual counties doing to address caseloads and backlog, and those case logs and backlog that just keep going up and up and up because we're doing the same thing over and over again. Charging, convicting, sending people to prison. It's the same cycle over and over with no reduction in caseloads. In fact, they continue to grow with the additional charges that are issued. So I give you all of this background because when I was brought into this, which was after the fact, after the investigation was conducted, and where Caitlin Frederick from the state court's office, so that's the court operations in Madison, was here. Unfortunately, I wasn't involved until after the fact, because I think there's a difference in how the questions would have been directed, because it struck me that in reviewing the reports and the end result, we somehow went from a single personnel issue to then, and I really don't know how this happened, to considering the dissolving of the drug court. I started with that, I'm going to continue with that, and that's why we answered the question we did, because the treatment court here in Rusk County is so incredibly important, because I think one of the other folks mentioned this, that all the funding comes through the Bureau of Justice, and there is certainly matching funds and in-kind services that a local county contributes. But if Rusk County were to decide that, say, the county board chair is the chief official in the county, decided that those funds were no longer to be utilized, because Rusk County, of course, is qualified for TAG grant. And if you decided not to do that, the reality is that it's a reimbursement grant. And so you wouldn't obviously receive any additional funds, but should you in the future ever decide that a treatment court was actually beneficial to Rusk County, it has been, and you want to reinstate it, it would be not until 2027, 28. These grants don't come along all the time. Once you're in the system, you're in, and you can continue to apply. But if you back out, those funds will no longer be available to you, and they're just going to go to somebody else. And so you won't have the opportunity to invest in your community again until 2027 or 2028. And so I bring that to your attention, because you have this opportunity now to continue the program, to improve the program, and all of those things were actually in play. And I don't know how many of you are aware of that the evaluation that was done last year, before Judge Barna took the bench, was done of the existing program, and it was done for evaluative purposes to better the program. I don't know of any company, organization, program, entity that is successful and doesn't constantly evaluate itself for improvement purposes. So that's what that was all about. And interestingly enough, this evaluation is still ongoing. So there are other evaluations that are taking place, and in fact, All Rise, which is the national, used to be called the national, essentially National Drug Court Program, they changed their name this year to All Rise, and they have been providing also mentoring and assistance in terms of various programs. And so it's those programs that I outlined in my letter that we intend to ensure continue to work for and with this current drug court. So I guess I'm not really sure exactly what questions you have for me about this, but I'm happy to answer them. From our perspective, the best way to handle this would be to ensure that the evaluation and then follow through that had already begun continues, and that it be allowed to move forward, including following up with multi-track training that the team did with All Rise, following up on especially these roles and responsibilities. That's a big thing for any drug court team. And I think Judge Stewart also clearly indicated this. I don't know any drug court team anywhere that doesn't have problems, that doesn't have discord, that has to work through that discord. And it's interesting to me to have listened to all the people who have stood up here in the public comment and talked about how much they support this drug court team, and that you have team members from every discipline that are required by the TAD grant to be on the team. And so obviously there is huge support for this program from the team members, and the team members want it to continue, and the team members want it to improve. And so that's where the District 10 administration can assist. We can ensure that this ongoing mentoring and training and programming continues. And in fact, one of the benefits to come out of this entire process is that All Rise is hoping or planning or strategizing to do this training throughout the 10th district and have all of us who are participating in treatment courts be present for that training, because we all have the same problems. I've been on our family recovery court, I've been a family recovery court judge, and I've been the adult treatment court judge. And in every team environment, there is going to be the need to continue to have open and honest communication. And that's one of the things I think was missing, was that honest communication. Because as I understand it, Judge Barno wasn't even aware of many of the comments that were made about her communication style or skills. And so I think that's one of the things that we can clearly assist with as we move forward. So I believe my letter answered the 3 questions, but I am curious if you have any additional questions or comments you want me to specifically address something, I'm more than happy to do that. But I think Rusk County would really do a disservice to its citizens and to this community, and certainly those it serves directly, if you were to dissolve the drug court. And I have to say, I'm not even sure how you do that, because it is a court function. And if you decide not to accept the money, I guess, would be what you're doing. So that's, I'm not sure how we got here, or why we're here. And I think that's the first and foremost, is making sure that everybody understands that. What is it? And one of the other gentlemen mentioned that. Is it because of personal bias or conflict? I don't know, but the drug court program here is incredibly important to the entire criminal justice structure. And obviously, you've heard from everyone working here locally that it's been successful. And I think what really needs to happen is those of you who don't understand the program really should take the time to learn it, to learn about it, come to the meetings. You can't obviously be at the staffing, that's all confidential, but you can come to the hearings, come to the open court, see what the program is doing, learn about the program. And I would highly encourage you to do that. So if you have questions for me, I'm happy to answer.
Speak up. I, for one, agree with everything that's been said. However, I've read some of the investigation material, and there's a hurdle here somewhere, along the line. So that's the hurdle we've got to get over. So if we can do that, I think we're good to go. That's Vicki. Anything else that?
Well, I agree that that's the hurdle. And to me, the hurdle is there has not been open and honest communication. And what I see is that someone has has a perception about how something is, and instead of directly communicating with the person, it kind of goes around like this telephone game until it finally gets to the point where it gets to someone who then takes it and does something else. I mean, we can all probably debate the process by which this happened, but I think we can also agree, anybody who had the opportunity to read the statements, that the most chilling thing to me was that at no time did any of the persons who made these statements actually discuss them directly with Judge Barna before this investigation occurred. And so, from what I understand, there were comments made about things that happened 3 and 4 years ago, before Judge Barna was even the judge. And so, the fact that we're even talking about things that happened that long ago in this discussion about eliminating the drug court today, to me indicates that the real problem is a lack of communication. And that's where this training and evaluation and planning can go a long way in terms of opening up those lines of communication and ensuring that everyone, first of all, understands their roles on the team and even in the CJCC, and how the team relates to the CJCC, which is basically an oversight committee. And I think that's, it struck me that it's the lack of open and honest communication that brought us here today. And frankly, especially when I read that the people who work the closest with Judge Barna have no issue, have not seen these things, believe that, frankly, some of the issues didn't even happen, or they certainly didn't happen the way that they were alleged to have happened. So that's where you see this problem when people are not communicating directly with each other. There's a set of facts, and people then assign a meaning to those facts. The facts aren't any different for everybody sitting here in the room, but all of us assign a different meaning to those facts based on our own perceptions and our own backgrounds and our own biases, our own prejudices. And so that's when we don't communicate those meanings that we've assigned to things to someone else, then that's what leads to this sort of conflict. So that's how I view this, and I think the sooner we can get a drug court coordinator appointed, get back to doing this implementation of all of the evaluation and the reports and the recommendations made, the better. And then we can get those lines of communication open between all of the parties involved in the team. And not just the team, but with the CJCC, and then hopefully also with the board, and then into the community. And I couldn't agree more with Mr. Newsberger that the community should be very aware of what's happening. And I agree with you. I think that's the hurdle. The hurdle is the lack of open and honest communication. And that can certainly be overcome. I don't see that as an issue, but again, it's gonna take everybody working together.
I think, I don't know what I can or can't say here without, so much of this happened in closed session. But I was in a part of it very early on. And I'm sorry to say, ma'am, that is not the hurdle, but I can't speak of the hurdle here because it was completely in closed session and there's private names. And that can't be brought out in open session. Because to a county, that's a lawsuit.
Who is the drug coordinator right now?
There isn't one.
So how is one named? What's the
Well-
process?
Well, I think that's one of the things I also addressed in my letter, that one of the things that we're recommending is that the Rusk County Drug Court Program, when it was created, was had the court as the supervisor. So it was a court run, it is a court function to be sure, but it had the judge or the court as the central supervisor of the coordinator. And that is not the usual model. The usual model, and not to say that it's right or wrong, but, the majority of the counties use a model where the treatment coordinator, the coordinator of the treatment court is, housed in DHS. So it's a DHS employee. That's how it is in Barron. I know that's how it is in the majority of the treatment courts across the state. But the coordinator is housed in DHS. That is an employee of DHS and is then supervised for personnel purposes by the supervisor in DHS. And that's how it is structured in our county. And so the personnel issues would be taken out of the hands of the court, and placed into the hands of DHS. And so that, we all support that. Judge Barna supports that, the 10th district supports that, the state court's office supports that. We support that. That is a model that's used across the state. So what I would envision is that the head of DHS, along with Judge Barna, the position would be posted, people could apply for it, and it would be posted as a DHS position. And then people apply, and then the DHS head and Judge Barna, along with, you don't have a human resource person, right? That's my understanding, there's no human resources here.
We'll get one on boards shortly.
Okay, great, so then your human resource person would all be involved in that interview process, and that person would then be hired to work with the treatment court team, but be supervised by DHS. So that's a model. So I think under any model, the position would be posted, and whoever the supervisor is would be involved in the interviews, and the judge, if the judge is not the supervisor, and I would recommend against that. I'd recommend against having the judge be the supervisor because of the unique role that the judge plays in a treatment court. And the judge has to be able to hear from each of the team members, but the judge is the ultimate arbiter. The judge makes the ultimate decisions in the treatment court. It is a court function, and so, but the judge relies on the opinions of others to then make determinations in individual cases. So it's not a team vote, although team members contribute. And so that's the best practice standard for treatment court. So that's how I would envision it happening, and that the position be, as soon as feasible, that someone is hired and you follow a normal hiring process to get that person in. But that the position actually be in DHS. If that doesn't work for your county, I'm certainly open to another, but I don't believe it should be, because this is where the confusion with roles and responsibilities are. It's not clear what those supervisory roles are, because I know one of the allegations is that the judge didn't have the authority to terminate that position. And it's not entirely clear that she did or she didn't, because the way the treatment court was set up, it was court supervised. But I think we're past that now. What we're saying is, get the position in DHS, get the position hired, DHS supervises it, but again, the judge needs to be involved in the hiring process to ensure that the person is indeed qualified and appropriate for that program. I know that our judge was involved in that hiring process. I wasn't the treatment court judge when the last one was hired. But that's the normal process, and that's how it works, and that's how I would envision it working here.
If I could interject, Rusk County has adopted ordinances, and they've created an ad hoc interviewing committee that specifies who's involved in the hiring process with respect to county positions. And the drug court coordinator is a county position, and it says the ad hoc committee shall consist of 4 members, 1 from the personnel committee, 1 from the oversight committee, the department head, and the administrative coordinator. So it doesn't, if Judge Barner was involved in the hiring process, it would violate Rusk County ordinances.
Yeah,
What's
well,
up?
I'm sorry?
I'm sorry for interrupting, but that needs to change.
Well, okay, I
It's
wasn't
a
aware
county
of
board
that.
decision.
Was not aware of
And it's
that.
time for the county board to start listening to their constituents.
So, so you said the department head, right? And, it strikes me, again, this is a unique function. And it's something that, you know, we're not accustomed to. The treatment court is, again, I would say that it is akin to this, the JA and the judge, or the court reporter and the judge. These are, the court reporter is state employee, so I won't use that one. But the judicial assistant, for example, is a county employee, but the judge is that person's supervisor. And by law, the court, it's a court function. And so by law, even though it's a county position, the judge is the one who determines if it's hired or fired. That position cannot be hired without the input of the judge, because it's akin to a personal appointment. It's not a personal appointment, this is a county employee, but it's similar to that. And under the Bartlett case, the court, because we're a separate branch of government, has that, I guess, a cooperative jurisdiction over that position. And I see that as the same thing with the treatment court coordinator, that this is a court function. And that, you know, I sure hope it doesn't come to this, but if, for example, for some reason the county chair decides that no, we're not going to accept any more grants, and we're not going to spend any more money and apply and use the money we've already been offered and received and delegated from the Bureau of Justice, it doesn't mean that the drug court necessarily ends. Judge Barno would have to find another way to fund things for sure, but there are treatment courts and there are diversion courts and there are other programs where it is not based on Bureau of Justice funding. So it doesn't necessarily follow, and again, I sure hope that doesn't happen, because you've already qualified. You already have this grant. It seems silly to throw that money back, or to not utilize something you've already been approved for and qualified for, and have right here behind you all of these people who are committed and dedicated to making this program work, to the extent that they were willing to bring in evaluators, which I understand now for some is being used against the team, that they were evaluated, and somehow it's now being used against them, that this is a sign that the team isn't working. Well, I sure hope that's not the case, because as I said, that's something that all organizations who want to improve and be better and be the best that they can be are going to do. I mean, any organization that doesn't evaluate itself, I think is going to fail. But I understand now that ordinance, but I do think in that spirit of cooperative effort between the two branches of government, the court and the legislative body that's here, that one would hope that the court would be involved in that process in some fashion, however that looks. But I think it does, it should involve the court. But again, these are things that we can talk about once the ultimate decision is made. Is at some point, can this position be opened up so that it can be filled? I mean, can we stop this process, make a decision, which is what I understand is going to happen tonight, that this board is going to make a determination that yes, we're going to have a treatment court coordinator. I mean, I don't know, I think that's what everybody's expecting. But again, no one seems to know what we're doing. And so if this is the decision time, as soon as the board decides that the coordinator position can be filled, I guess that's maybe what we're doing. If that's the decision, then let's fill it. And however it looks, however it works, we'll make that happen. And we're certainly going to cooperate with any plan to make that happen, but that first decision has to be made. So if you're telling me that's the decision, that's great. I'll participate in it if you want. But let's just get that decision made that it's going to be filled and get it done. Because this team, as you can see, is in dire straits. They need that coordinator. They can't operate without it. It's a requirement of the TAC grant.
Jim, did you have a question?
Yeah, so it sounds like from some of your comments here tonight that this maybe was never set up correctly in the first place. And let me finish before you respond. Sorry, I should have clarified that at the beginning. Because my understanding was when I came on the board that this position, drug court coordinator, answered to the judge, but yet the money from the TAD grant comes through the county, goes through the finance department, but yet we really don't have any say over it once we accept the grant. Which, I'm sorry, but from the state's aspect, that's wrong. If you're gonna run the money through the county and tell the county you're responsible for this employee that you're gonna hire and put in anywhere in a judicial system, and I'm not even, this has nothing to do with Judge Brown, I don't care who the judge is. The program in general, in my opinion, is messed up. You guys want it to work, but yet it didn't sound like maybe there was a lot of thought process put in how it was gonna work with different sized counties. Some counties have a huge health and human services department. Ours is fairly large, and thankfully, it helps our county out a lot, I feel. I don't think anybody from the last board meeting at this table, all the way around it, wanted to get rid of drug court. We were to the point where we didn't know what to do. And we felt our hands were tied. At least I'm gonna speak for myself. I felt my hands were tied behind my back as to how I could represent this for the constituents in my district. So to just sit here and sign off on things or have ourselves put into what I call possibility of a liability issue, I'm just gonna leave it broad. And then the county's gotta just pick up the tab. If you understand, I'm gonna be very vague on this, but if something was to happen anywhere with a state employee that's hired by that come through grant or whatever, and then it's a county employee becomes involved, county's gonna get stuck with the bill, not state. That's where I'm a little frustrated with the whole thing. I think the program's great, I'll put it on record. But there's some things that gotta be fixed. There needs to be more, I think there needs to be more, if the board's gonna be in charge of the money that flows through, fine. You wanna take the money and set it up for the state and fund the whole thing to the state? Great. Take it right out of the coffers here. We'll throw our match in like we do now. What's our match right now?
25%, so about 45%.
25% county kicks in for this program. I've spent more time in meetings over this $160-some thousand budget for this program in the last 6 months than I care to. I've got other things to do. Not that it's not important, otherwise I wouldn't be here. But it gets frustrating.
Someone else gonna say something before?
Well, I was wondering then maybe the state would, accept the liability for the employee, like the drug court coordinator, then if there was any issues there.
Well, I can't comment on that because I don't know that there is liability, so.
But if something came up then.
Well, I can't speak on behalf of the state. I'm the chief judge of the 10th district. I'm appointed by the Supreme Court as an administrator for the district. I don't speak for the state. So I can't answer that particular question. I understand where it's coming from, and I can appreciate it. I can appreciate your comments as well. And I'm not saying that it was set up wrong. There is no right or wrong as to how these grants were initially created. But when the grant was initially awarded, and I have to be clear that it's not like monies are sent to the county. This is a reimbursement grant, which means that there is no money to administer. What happens is that the team provides services, and then those services get reimbursed, including, and again, I don't know specifically how yours is, if the salary for the treatment court coordinator comes out of that grant. It depends on how the grant was written and what was specifically requested in the grant, but it's a reimbursement grant, so there is no money for you to administer. The money isn't given to us in a lump sum and then we spend it however it seemed fit. The treatment court program is administered by the Bureau of Justice, the TAD grants are administered, and it's essentially receipts are sent to them. So, when a team goes to training, for example, then those receipts and all of that gets sent to the Bureau of Justice for approval for those monies. So we don't actually get the money, but the amount of the grant we are aware of, and then it's a reimbursement grant. So there really isn't anything. And the grants are available to counties, and from the state perspective, from the statewide treatment office in Madison and the Bureau of Justice, the chief county official is the chair, is the county board chair. And so that's who signs the grant, who signs the grant request. And then the team administers the services and then requests reimbursement for those. So the matching from the counties is generally in kind in terms of paying the salary, for example, of the treatment court coordinator. I know that's how that's done in many counties as well, that the county picks that up. I can tell you in my own county for years and years that's happened, because we weren't receiving or awarded a very large grant, and our county just supported the program to the extent that the treatment coordinator was paid by the county. And so it really depends. Every county is different, and so that's up to the counties to determine how this is going to be administered and what the monies are for. But it's generally already included in the grant that is then approved by the county board chair and as the chief official. So the only people who can apply for these grants are counties and tribes. So the state of Wisconsin, for example, couldn't do that. The state court's office wouldn't be able to apply for that.
Judge Boyle, can I clarify something for everybody? When we originally got the grant for the drug court in 2014, when you say that it was set up wrong, that position, the coordinator position, was not a county position. It did not become a county position until 2017 or 18.
It was later.
And it was
Can
actually.
you use the microphone, Judge?
So for the first 3 years of the grant, it was a strictly contracted position, and it was the team who hired the coordinator. We had our hiring team, everything was done on a contracted basis. And so in 2017 or 2018, we had, we've had a lot of turnover in the coordinator position. We've talked a lot about that throughout the history of drug court. Some of that is rural county, some of it's experience, and it's a tough job. We talked about the many hats. So because in order to help alleviate that turnover that we had in the first 3 years, we, along with the grantors, asked if the county would make it a county position, because we thought that the benefits that go along with the county position would help to maintain longevity in that position. It just so happens that ever since it's become now a county position, there hasn't been as much interest in those benefits. In fact, even just recently with another drug court coordinator who wanted to come back into this position, she wanted it to be a contract position rather than a county position. So it wasn't set up wrong per se, that's how it was set up. And again, you know, I think it was 2017 maybe, that we asked the county, whatever the resolution was creating that county position, that's when it was. So we didn't run it that way to begin with.
Is it possible to go back to a contracted position?
Absolutely.
Just because, I mean, right now if you got this boss over here and this boss over here, and then you don't know which boss is the right boss, it makes it kind of confusing for employees, you know, because one's paying their wages.
To what I can.
Not, so.
And in fact, we have had other options, like now, having Westlake do the payroll portion of things, so contracting that way, where we didn't even know of that option when we first started it. It was just completely contracted, and they showed their own insurance, or I think might have went through the county as volunteer. I think it was all contracted, but it's been 9 years, so I don't remember. But yes, it could be.
The other question is, somebody mentioned having like a county board rep on the drug court team, is that something that's actually allowed, or is there something that we're restrict creating like a county board position on that team?
So there's a difference between being on the drug court team and being on the drug court oversight. So, and again, because we do have quarterly meetings with oversight that are department heads, and the team itself is a closed meeting every Wednesday where we talk about very personal treatment things, personal histories of our participants that should not be shared. Protected under HIPAA, and we're not medical personnel, but some people on our team are. So to have someone either on the team or on the oversight, definitely on the oversight. In fact, our oversight just met last Thursday, and that's one of the things going to youth justice this week, depending on the decision tonight, is to ask that a member of the oversight, youth or justice and youth, I always say that wrong, that they actually, one of those members are appointed to the oversight team, and the team supports that. We talked about that last Thursday, so yes.
Harry?
And I guess Jim halfways answered my question, I guess. And I too, I know people who are in this program and have went through it. My issue is the way things are set up by the state. The state is in essence hanging the county in a very bad position, because you stated, Vicky, you holler at me if I go too far. You stated that the judge in this case would have the case to hire and fire.
No.
Yeah, you went back on a case law that's.
That was judicial assistant, for judicial assistance.
But you stated that this coordinator position was.
Akin to that.
Right.
Right, but they wouldn't, they don't have that authority. So if I don't want you, I just wanna correct that. The point I was trying to make is that there are cooperative efforts and, between the county and the courts. A legislative body and a, court body. So it is two separate branches of government, and so the point I was trying to make is that we do work cooperatively in some circumstances when it involves county employees and the courts. And the JA was one example. This isn't exactly that, but to me, it provides a framework from which we could, and again, that was it was my answer to Ms. Sultan's description of the ordinance that you have. This was my solution to that problem, was that maybe we work cooperatively like we do in other areas to ensure that the court, as a separate branch of government, is involved in this decision-making regarding a court function, while the employee is a county employee. And again, this is just the natural consequence of how, of our state court system being duly funded by the state, where the judges and the court reporters and the computers for them and all of this other stuff is funded by the state. And then the county, though, provides the buildings, provides personnel who work. You know, it's unfortunately, that's the system that was set up back in the 70s when the court system became somewhat unified. And it has no doubt created conflict between the counties and the state. And so what I was suggesting is that we attempt to work cooperatively like we do with the judicial assistant positions.
And that's what I understand. The only issue I have with the program, the only issue at all, is how the state puts a liability issue on the county. And as a county, we are strapped beyond belief as it is. And I don't feel it's right to use our county's taxpayers' dollars to pay for a liability issue that is or isn't, did or didn't, whatever, of anybody could be, for something that the state is actually liable for and put us in that position.
But the state didn't put it on the county. When the grant was submitted back in 2014, it was a model that didn't involve that position being a county position. When it became a county position, it was discussed with the county board at that time. A resolution was passed. We explained the reasons for it, and I'll be open, I don't wanna speak for Judge Anderson, who was the judge at the time, but I was on the treatment court team at the time, and it wasn't something that I was fully supportive of because of the way that things are run, but we also were struggling with retention of coordinators, and we really thought it came down to the fact that we weren't offering benefits, and I don't even know if we were full-time. If the coordinator, coordinator didn't start full-time, it started part-time. And so this is what morphed into it, but it was all a discussion with the county. This isn't how the state told us to set it up. We applied for it. We worked with other counties like Washburn County. We modeled it after that, and we ran it for 3 years without that being a county position. And so, I mean, if that's the county's concern, then yeah, there are options. We can go back to that. There are other counties out there. I checked. I know there's for sure Burnett County is very comparable to us. Their position is not a county position. It's 32 to 35 hours a week. They do not offer benefits. I believe Taylor County may be another one. I'd have to pull out my papers to say exactly, so I might be naming the wrong counties. But for sure Burnett County and other ones that just, they contract.
And don't get me wrong with what I said. I'm not trying to speak for the entirety. That's what I feel about what I was saying. So.
Sure. And yeah, and if you weren't part of the process back in 2017, how would you know that? There's a lot of history here. 9 years we're going on here, 10 here. So it's been a long time.
Anyone else wish to speak? I know you're on the drug court team, so.
If I could address Mr. Meyer's concern about the accountability, and I agree with you and I agree with Terry that there's gotta be some level of accountability for funds going forward. However, one of our concerns as being on the drug court team is on occasion, and sometimes more frequently than we care to, we have to send participants for inpatient treatment, and it's not a situation, and it's a fairly expensive process. It's not a thing that we can run through a couple of committees to reach a decision to get them in. It's like, we call up treatment providers and say, can we have a bed? And they say, yes, you've got one available tomorrow, and we send them, because it's an immediate need that occurs. If we could find a way to take care of that and provide that in, then I understand your need for accountability, but sometimes we have to act without the overall board oversight that perhaps the purchase of a squad car or something would take. Did that address some of your concerns, Mr. Mayor?
Well, yeah, but I mean, right now, correct me if I'm wrong, Jamie, those expenditures come through finance. So where my concern comes from is any department, I'm on finance, my name goes on that finance sheet at the end of the month, and I try to look over everything. Do I miss some? I'm sure I do. But there's been different things that have come through from that department that I'm like, okay, and I question them. But the county, because of it coming through, in a way I look at it, and maybe you disagree, just Boyle, I feel I'm responsible to a point by putting my signature on that payment approval monthly if something comes through from drug court. The same as HHS, highway maintenance, whatever. And trust me, there's been plenty of us in finance that bring up different things from different departments that one of us catches and the other four do not. But I guess that's where I'm going with this. I mean, we're still responsible for the expenditures that come through from drug court.
Can I ask, so when you have a question like that, what do you do? Who do you talk to about it when you have that question? Do you send it to the drug court team and say, hey, I was reviewing this and I have a question about this expenditure, can you explain it to me? I mean, what do you do when you have those questions?
I pay to the finance director. I expect her to get the explanation if I need one.
And we send it back down where it came from, whoever put in the invoice, we send it to them and expect them to.
Okay, so then, and so you've done that, you've sent some things back to the drug court team and say, what was the basis for this?
Absolutely.
Okay, so what is the problem with that process?
And I'm not saying that this happens all the time, okay? I don't want anybody to get that impression that monthly I'm on the judge about drug, that's not it. I'm talking about the fact that the TAD grant comes through the county. I feel we're responsible for it. So we should have a right to question how it's handled. If the state wants us to not have any say in it whatsoever, then make the drug court coordinator a state position, as well as the judge, the grant, and do as you wish with it. Which, either way, I think, I mean, that would work too, and be done with it. And then we wouldn't be having this meeting, right?
And under our policies and procedures, any purchases, any large purchases are to go through the oversight committee, which is the Justice Youth and Extension Committee, not the drug court committee for budgetary purposes, as well as, equipment purchases at that time over $1,000 were to go through the property committee, and so those procedures were not being followed.
Well, I want to comment on that, since you did bring it up, is that we do not have a problem following the county procedures about any of it. It's just that the directives from the county changed. We didn't have to, everything within the grant has to be approved by the grantors. If we deviate from the budget we submit, we have to do a budget modification. We have to ask for permission in writing before we even do that budget modification. And part of this, and when this evaluation was conducted last summer, we have a new coordinator, we have a new finance director. The way things have been done, and I can personally say that we would follow whatever the county said. Okay, anything over, I think at the time was $600, then we'd have to seek approval from property before we could do that. At that time, we'd go back, and then it was, Annette, why do you keep coming back here and asking? I mean, don't the grantors have to approve this? Yes, I explained the process, and they'd say, we don't need you to come back here every month and ask us. Totally different property board, that changes every 2 years, we get it. So if things change, we just need to know. And so it's been very clear now, but when there have been questions, they have not been brought back to the team. They were brought back to the person who submitted the invoices, who is not an intricate part of the drug court. And that was done because it was a checks and balances because of an issue with some money and some things that had happened way in the past with a different coordinator. So that was a checks and balances. So when you posed a question, it didn't come to me or to the drug court team. It went to the person who just comes and says, can you sign this invoice? And so I think the conversation in an email between you and I was, please contact me about this because I can answer those questions readily rather than go to somebody who isn't involved in that process. And so this is where the open lines of communication would be helpful. When we're told from one property committee, we get it. You have your checks and balances with the grantors, so you don't have to. Like I said, that changes every 2 years, and we don't have a problem with that. But it's just to say that we're not following the procedure. We've done it the same way for the last 9 years. And now we were informed that we need to do this differently. The money amounts have changed. We don't have a problem doing it at all. And we can show that we have always gotten permission from the grantors before we deviate from anything within that. And we will work with the county and follow whatever rules. Just like the hiring and firing, we just have to know when they change, so that we can do that, so.
Can I just say that this was a perfect example of the lack of open and honest communication. So that there were changes, perhaps not communicated, and this should not be done by email. That's another problem we see. That the communication should be person to person. And so I can see that that's an issue here. So to me, I think all of these issues are solvable and they are addressable. And your concerns, they're all able to be addressed, but they have to be addressed through open and honest communication. And I think probably some people here are hearing your concerns for the first time, or some people here are hearing these concerns for the first time. And there needs to be just this direct communication, and it should be person to person, not through email, not through the back door, not through closed session, not through investigative reports, but instead there needs to be this communication. And I think we just saw a prime example of that, where there was a difference of understanding. It doesn't make it wrong or right, but it is a difference that then leads to the problems. And I think, again, this, if the county's gonna decide that the coordinator is not going to be a county employee, then fine. But let's make a decision. And if that's your decision, the county doesn't wanna hire a coordinator, then it'll be up to Judge Barna to figure out, well, how are we gonna get a coordinator? And how are we gonna do it? And are we going to apply someplace else? There are other counties that have contracts. And so if that's the case, but you just need to make a decision and get that part done, so that then those people who really want to move this forward can do that. But I think everything we've talked about here tonight is clearly resolvable with just open and honest communication, and also just people being open to different ideas and being creative, because that's what these treatment teams do.
Judge Barna, do you remember why the board, because it was before my time, why the board chose to go with the county employee, other than, you said benefits, but do you feel that a consult type position is feasible? Or contracted, I should say, sorry.
We did it. I mean, we did it for 3 years, and it worked fine. We were really trying to brainstorm, how can we retain a coordinator? And so we went from part-time to full-time, thinking that was it, the amount of hours. It was really hard to get anybody then. I mean, times have changed now. It's hard to find employees, period. But then it was part-time. Nobody wanted to work part-time. So then we went to full-time. And honestly, Judge Anderson, I don't know, maybe you could speak up, but my recollection is we had one particular person who wanted to get state retirement, but not the insurance or anything else. And the only way that we could do that was to have it a county position. So we went to the county board. At that time, we didn't even have an oversight committee that we talked to about anything. So we went to the county board, and that's what we did. And the grantors came up and talked about it. They encouraged it. If this was gonna be a way to retain a coordinator, to allow benefits, we could change our grant and ask for more, because we didn't ask for another $30,000 for benefits before. And like I said, I mean, we could go back and look, but I think you'll find in the history and in the documents that since we did that, the majority of the coordinators that we've had, because we still have had a turnover in coordinators, but the majority of them did not elect to either take some of the benefits. So yeah, it can be done. We did it that way for 3 years.
Because I mean, honestly, what's been in the last 2-3 coordinators we've had, without going into any detail, I mean, what, a couple, 3 years each one? I mean, it's probably the longest they've stayed, so what?
No, not the longest.
I'm not sure how much they've gained off the state or the county's benefit system, other than, insurance.
And I think we have data that would show that if they didn't elect to take it, then you're right, that is a valid question. Did it help any to retain anything? So, I mean, I would want, to actually crunch the numbers, because my memory's not all that great, but yeah, to answer your question, what doesn't change is that we have to apply for the grant under the county's DUNS number. That's a requirement of the DOJ grants. And so, I don't.
Do you remember, Lori? I mean, we had to use the county's grant DUNS number
for sure to apply. So, and then actually the acceptance of the grant had to be, the contract had to be signed by the county board chair the whole time. But like I said, we didn't have an oversight committee, and I don't have a problem with having an oversight committee, but we didn't go monthly and report anything. Everything went through the grantor's permission with them, and then we had to do the quarterly reporting that went through, Rosemary and then Kitsy.
Mr. Chair. Would you, I guess I'm curious to answer the other part of Jim's question. Do you feel it's feasible to go back to that? To a contracted position versus a county position?
I see the pros and cons both ways. Feasible, like I said, times have changed. It just really seems like everyone is struggling to find employees for any job. I mean, people didn't leave county employment before, and we've had how many in the last 2 years here? I mean, the turnover in the county alone is big. So, we can do it, I will say that, but feasible, I would think that it would be, the best thing to do would be to sit down and talk about the pros and cons with whatever body that is with the county to say, but yeah, we could go back to that. Like I said, we did it for 3 years. But it still doesn't change the fact that the grant has to be accepted by the county. If that makes sense, but the checks and balances with respect to the money is done through the grantors.
All right, let me speak to this feasibility about going back to contracted position. The reason why we started with a contracted position was not because we thought that was the best way to do it. We didn't think that this is a way to do it to save the county a lot of money and to get an employee in there. We did it because we didn't think there was a resolve on the part of the county board to create a position, a county employment position for a drug court coordinator. Because in August of 2014, when we started our drug court, we started it halfway through because that was that odd year where they provided grant funding halfway through the year. Drug court was something that Rusk County had never had. I don't know if anybody had ever heard of it here in Rusk County. I know other counties had them, and when I went to judicial conferences, I heard about other counties having them, and I thought, I think Rusk County needs to have one too, to take advantage of the programming for the people here in the county. So we got together, Judge Barna, Ms. Gorsigner, and I had sat down, and the work was mostly done by the other two. I was there, but we put together a grant proposal, and we got the grant. And so we started the drug court, again, as I said, which is something that this county had never had, and we didn't see at the time that we thought that the atmosphere or the politics or something wasn't right to come in and say, we need a drug court coordinator, let's create a full-time position with full benefits, and you guys pay for it. We had grant funding for a contracted position, and we found people who would come in and be part-time contracted drug court coordinators. And at that time, part-time was legitimate. We didn't have a full-time operation. We were just getting started. As Ms. Barna, Judge Barna points out, as the years went by, we got up to our 14 to 16 threshold. That's what we started the drug court to accommodate, was 14 to 16 people. We had 14 to 16 participants, and then we found that the drug court coordinator was spending more and more time managing those participants. And so that's when, as Judge Barna points out, I don't know, it was 2017, I don't know, I thought it was a little later than that, we started to move towards an employment position that would offer benefits. And that's where we are now. But as far as the drug court coordinator being supervised by the judge, that was at that time the only person to supervise, because it wasn't a county employee, it was a contracted part-time position. But that's how it evolved, and you guys know how these things evolve. Part-time employees become full-time employees, and that's how this evolved as the drug court became more and more successful. more and more participants entered into it. But I understand, Mr. Meyer, I guess I understand your concerns. It is a hybrid situation. It's not a normal kind of thing where you pay for what the highway department does, or you pay for what some other department does in the county as a finance committee member. It's a hybrid situation. This money, or the reimbursement, as Judge Hoyle points out, is coming from a grant from the state of Wisconsin. The drug court is responsible for seeing to it that the vouchers they put forward meet our grant requirements. So there's the first check on the expenditure. The drug court has to be satisfied that it's legitimate. Then it passes through your office, then it passes through the state office. And if it's reimbursable, then it gets reimbursed. So, you're working in a situation which does cause discomfort, I think, just from the financial standpoint. But as you move towards considering this drug court coordinator being a county employee outside the court system, in the Department of Human Services, you've got other considerations that you have to take. Is it feasible to go back to a contracted position? Anything is feasible, but I think what you may find is somebody's gonna come in and say, if I'm a contracted person, I don't want X number of dollars a year. I want X plus this because I gotta insure my family. Or you're not giving me paid vacation or paid days off. I want extra money because of that. So there's all kinds of things to consider when you try to discuss how we're going to, how we're going to formulate this position. Thank you.
Thank you, Judge Anderson. Anyone else? Any other questions? Not sure where we go from here.
I think it comes down to, do board members feel like there's a need to go into closed session to, you feel like your questions have been answered, the 3 questions that were proposed back on August 23rd, or do you want to go into closed session to be able to candidly and be able to talk about the personnel issues that can't be talked about in open session? That's the board's desire, then someone needs to make a motion to go into closed session.
Any thoughts on that? If you have questions that you feel are, were discussed in closed session and you want to bring them up again, now would be the time to do it. So
I'll make a motion to go to closed session.
You'd have to read do you have the agenda?
Want me to read it?
Yeah.
That's the chair's, that's the chair's duty once it's seconded.
Oh, okay, sorry.
Okay, John, how do you
do we want to go into closed session? Okay, I will read the, chair at this point will call for a closed session.
Need a second. Got it.
Okay, chair will call for closed session. County board chair may entertain a motion to go into closed session pursuant to Wisconsin Stats 19.5, C, for considering employment, promotion, compensation, or performance evaluation data from a public employee over which the governmental body has jurisdiction or exercises responsibility to continue the discussion with intense judicial district staff regarding Rusk County's drug court program and hostile work environment concerns. Performance issues of individual non-elected county employees arise during the course of the discussion in open session, and or if conferring with legal counsel for the governmental body who is rendering oral or written advice concerning strategy to be adopted by the body with respect to litigation in which it is or is likely to become involved. Motion to go into closed session was made by John Undershoots and a second by Jim Meyer. So you may vote to go into closed session at this time. 14 yes, unanimous, so we are going to close session. Okay, after considerable discussion, so the chair will entertain a motion to submit for the TAD grant.
For the 2024 TAD grant.
And move forward with the coordinator hiring process. Motion is in order. We have a motion by Tony Hauser and a second by John Caleb, so any other discussion on that?
Hey Randy, can you read that motion one more time, because I don't take the power to it.
Okay,
Ready?
go ahead.
Motion by Hauser, second by Caleb, to submit for the 2024 TAG grant and move forward with the coordinator hiring process.
Any other discussion? If not, you can vote at the present time. Vote is 14 yes, so a unanimous vote. Any announcements?
So I'd like to introduce Lynn, if you want to stand up quick, to the board. She is going to help us out on a limited term basis with HR initiatives, and she will be a great resource for the staff as we head into open enrollment. So Lynn, this is the board. And if you guys have any questions or you want to just chat with Lynn, please let me know and I'll get you in contact.
Thank you, everyone. I'm happy to be here.
Anything else? Not? Motion to adjourn.
Thanks, Robert.